Okay, guys, welcome once again to another episode of Scott Talks Law. So, this is an episode whereby Scott Talks Law, and in this particular episode, we shall be talking about criminal procedure and practice, and we shall be talking about bail and bond under criminal procedure and practice. So, we shall be looking at the definitions of a bail and a bond, and we shall also be looking at the compelling reasons that a court may grant bail. We shall also be looking at bail consideration for a child and bail under minor offenses or minor crimes. And we shall also look at the securities under bail, securities and under bail. So a bail and bond. So a bail refers to the temporary release of an accused person on the payment of a particular sum of money or particular amount. So the temporary release of an accused person awaiting the trial, sometimes on condition that a sum of money is lodged or guaranteed the appearance to court. So this is whereby an accused person is released temporarily after paying some particular small amount or particular amount of money prescribed by the court. So this person will be released temporarily under bail. So under bond refers to the undertaking entered by an accused person to comply with the conditions set by the court. So the bail is where you are released temporarily after you pay some particular sum of money. So the court has discretion to grant bail in extradition cases where when determining whether to grant bail, each case should be dealt with on its own merit. So you have different types of cases. So each case, depending on that particular case, it should be dealt with depending on the merit of that case before bail is granted. So in R versus Bakitash, Akasha, Abdallah, and three others, R versus Bakitash, Akasha, Abdallah, and three others, the release on bail bonding trial. It's about the release of bail bonding trial. And the accused person have the right to bail except where there are compelling reasons for the denial of bail. Every accused person have that right to bail trial. Every accused person has the right to bail trial except where there are compelling reasons as to deny the accused person the bail. So an accused person need not to make a formal application for bail. It's therefore granted as a matter of right unless the prosecution raises an objection based on compelling reason of Article 49 sub-Article 1 of the COK. So this is just of the Constitution of Kenya. So this is just an automatic right that an accused person has to have that bail. So I accept the prosecuting side raises compelling reason as to why the court should deny the accused person bail, then the accused person has an automatic right to be granted bail. So the court's decision as to whether to grant bail or deny bail should be guided by Article 49 of the Constitution of Kenya, the rights of arrested person, and Section 123 and 123A of the CPC, the Criminal Procedure Code, and the Bail and Bond Policy Guidelines 2015. So determining whether to release an accused person on bail must be distinguished from the determination of the person's guilt. Thus, the court should take care not to be influenced by the statement of the witness or the evidence that may have come to its attention. So the court should not rely whether this accused person was guilty or not in order to give him bail. It should be independent from the determination of whether guilty or not. So the court should not consider the evidence or the witness statements provided by the witness in order to grant bail. It's just independent of whether this person is guilty or not. So the court should not rely as to whether this person is guilty or not to grant bail. So for instance, the documents similar to the committal bundles for the abolished committal proceeding are sometimes placed in court files in murder cases prior to the hearing. So documents similar to the committal bundles for the abolished committal proceeding are placed in the court files for murder cases prior to the hearing. So let us look at these compelling reasons for the denial of bail. So a compelling reason to deny release in context is one that is weighty and persuades the court that an accused should not be released. So these compelling reasons need to be weighty. It's supposed to be weighty. You must give sufficient reasons as to why you should deny this accused person bail, because it is his rights according to Article 49 of the Constitution. So if you are to deny this person his rights, then you should give compelling reason as to why, or the court should give compelling reason as to why you should deny the person the rights that he has according to Article 49 of the COK. So in the case of R versus Danford Kabage Mwangi in High Court at Nyeri criminal case, R versus Danford Kabage Mwangi, the prosecution has the burden to prove that there are compelling reasons to not to deny the release. So the prosecution has that burden to prove that there are compelling reasons to deny the release. So the court has the burden to prove that there are compelling reasons. The prosecution has the burden to prove that there are compelling reasons. So in R versus Danson Mugunya and another High Court at Mombasa criminal case number 26 of 2008, R versus Danson Mugunya and another, to deny bail, the prosecution must provide cogent evidence and not mere allegations. The evidence must be cogent. It must be not just a matter of allegations, and here it must be cogent evidence so that this person can be denied bail. So the prosecuting side has that duty has that burden to give cogent evidence. So in Job Kenyatta Musoni versus Republic, the court allowed a bail application and held that mere allegation that the accused was a flight risk did not suffice. The prosecution ought to have substantiated its claim. So the prosecution ought to have substantiated its claims that just mere allegation that the accused person ought to suffice a flight didn't give that sufficient reason, compelling reason, that substantiated claim as to why this accused person should be denied bail. So the compelling reasons may include likelihood that the accused will. So these are the compelling reasons. There are like 6 compelling reasons. So the first one, will fail to attend court after being given bail. So if the accused person will not attend court after the bail, then there can be a reason for the denial of bail. According to section 123A 2A of the CPC, in Job Kenyatta Musoni versus Republic, the High Court at Nairobi Criminal Appeal number 399 of 2012, the court stated that the key consideration when denying the issue of bail is whether the accused will attend the trial, whether there is a likelihood of abscoring them or retracting the disposition. The court in R versus Salim Said Nasoro and 2 others, in R versus Salim Said Nasoro and 2 others, stated that the seriousness of the offense as per se is not a ground for denial of bail. An accused as foreigner charged with terrorism offense who had no ties in Kenya and who had failed to provide a Kenya security was considered a flight risk. So the seriousness of the offense does not determine or make an accused person to be denied a bail. So in this case of R versus Salim Said Nasoro and 2 others, the court stated that the seriousness of the offense as per se is not a ground for the denial of bail. And according to this case, accused a foreigner charged with terrorism offense who had no ties in Kenya, who failed to provide securities that guarantor, and who was considered a flight risk. Ole Daji Shita versus Republic is also another case. So if this person will fail to attend court, then a bail can be denied. It can be a compelling reason as to why bail should be denied. So the second compelling reason is to commit or abet the commission of a serious offense. So if the accused person, after being released, is in a position of committing a serious offense, then the bail should be denied. In case of R versus Frederick Oleilman and 4 others, the accused person had been charged with 4 counts of murder. The first deceased was an advocate acting on behalf of the second deceased, and prior to his death had filed a report at the Independent Policing Oversight Authority alleging that he had been harassed by the first applicant. The court denied the accused person bail because they will commit further offenses if released. So if the accused person will commit further offenses according to the case of Frederick Oleilman and 4 others, then the bail should be denied as the second reason as to why a person shall be denied bail. So in the case of R versus David Menigwo, the accused had been charged with murder with murder of his wife, and one of the witness was his 8-year-old daughter. So the court denied bail, holding that under the circumstances, there was a likelihood that the accused will harm the witness. The decision to deny an accused bail on this ground ought to have exercised with caution, as it may amount to an assumption of guilt. So when the accused person has that risk of committing further offenses or crime, then he can be denied bail. In this case, the accused person was accused of murder, and the witness here was an 8-year-old child. So if the release of this accused person the release of this accused person could endanger this 8-year-old child, because the child was the witness. So the court in these circumstances will deny bail as a compelling reason for the denial of bail under the case of the Republic versus David Menigwo. So the accused person can't be denied bail if it poses a threat to the witness, according to the case of the Republic versus David Menigwo. So another compelling reason as to why bail can be denied is the endangering of the safety of the victim or individual, public, of the public. So endangering the safety of the victim or individual or the public. Victim, individual, or the public. So if the release of this person will endanger the public or the victim itself, then cannot be released on bail. So in the case of R versus Richard David Alden, the court denied a claim that an accused should be denied bail because the case was highly publicized, and therefore the releasing of an accused person will cause a breach of peace and public order. So the court held that the accused prosecution's claim was speculative and that it had not provided evidence for demonstration of likelihood of unrest. So the case did not demonstrate of any likelihood of unrest. So the releasing of the accused person did not provide any threat to the public. The case of R versus David Alden. So he must demonstrate the clear likelihood of unrest, so that the accused should be denied that bail. So the fourth instance is where there is interfering the witness evidence. So if you release this accused person, the release of this accused person will cause the interference of witness evidence, then person should be denied bail. So the case of R versus Richard David Alden, the court overturned the magistrate's court ordering the detention of the accused and releasing him on bail. The High Court held that there must be evidence of actual interference, of the likelihood of interference. The protection and agreed that the employer and employee's relationship between the accused and two other witnesses suggested a likelihood of interference with the witness. So the court, however, held that a mere relationship between the accused and the witness, especially that one, was not a vital and did not stand alone to prove likelihood of interference. So just a mere relationship between an employer and the employee did not result to the interference of the witness, evidence of the witness. So the court held that the relationship between employee and employee did not interfere with the witness evidence, according to the case of R versus David Alden. So in the case of K versus R at High Court Cabernet, the court held that the fact that the accused was the father of the complainant child created likelihood of interference in the court evidence. So created a likelihood of interference. The court therefore upheld the superstition on bail, which was to be restated once a complainant had testified. So the court held that the relationship between the father and the son could interfere with the interference with the court. So the court suspended the bail, which was to be restated. So this court held that the relationship between the father and the son, releasing the father will cause the interference with the witness, who is the son. In the case of R versus Frederick Oleleman and 4 others, R versus Frederick Oleleman, the court denied the accused person bail in a murder charge on the basis that there was real likelihood of interference with the witness. So the court noted that the deceased person was found dead after attending a trial involving one of the accused persons. Further, all the accused persons were well-judged influence because they were the administrative police and residing in the same area as the witness. So the people who attended the trial of this accused person were deceased because they were found dead, the three people. So the releasing such people will endanger their life or they endanger the life of witness. So the court noted that the deceased person was found dead after attending the trial involving one of the accused persons. So further, all the accused persons were under the influence because they were administrative police. So these accused persons were administrative police, and they're residing in the same area as the witness. So the witness were living in the same area as the accused persons who were police. So releasing this person on bail, then it will be endangering their lives because they will be dead. They will be killed because there were people who died after attending the trial that involved those police men. So the court also noted that some witnesses had been placed under witness protection and those who had not expressed fear of imminent danger. So these people were afraid of this police, and some of the witnesses claimed that they should be placed under the witness protection place where the witnesses are protected because their lives were at the imminent danger, and those who were not placed at the witness protection chamber claimed that their lives were in imminent danger. So releasing this accused person will pose a threat to the witnesses, those people, to the witness. So the fifth instance is where there is endangering of national security or public safety. So in the case of R versus Diana Suleiman Said and another, R versus Diana Suleiman Said, the accused was denied release because he had been charged with 12 counts of murder during attack in Lamu, and the attack was going at the same time of hearing, and the court held that releasing him would pose a threat to the public safety. So this was an attack in Lamu, and as the attack was ongoing, they wanted to release this person on bail. So the court was in fear that releasing this person will pose serious issues because the attack was still ongoing and it will affect the public safety or security, because that attack was still ongoing in Lamu, and these were the victims of that attack. So if the Al-Qaeda or Al-Shabaab who are involved in this attack, and we have some of the suspects who are arrested, these people should not be released on bail, because when releasing these suspects, it will be posing a threat to the public safety or the national security. So in the case of R, in the Republic versus Ahmed Abulatati Mohammed and another, Ahmed versus Abulatati Mohammed and another, the court denied respondents bail in the view of intelligence report that linked 85 kilograms of unrecovered explosive material to the respondents. So the court held that the threat to the national security posed a compelling reason to detain the accused. So there is an intelligence report that there were 85 kilograms of explosives. Maybe they were bombs. So if these are Al-Shabaab or people who threaten national security or public safety, then releasing them will pose a threat to the national security, because the explosive material then so these people can then go and explode those explosive materials and then pose a threat to the security. So these people should be denied bail. So the sixth instance is to protect the accused person, and this according to section 123 subsection A, 2 and 2B of the CPC. In Malindi Swale, and in the case of Marimbi versus Republic, the court took judicial notice of instances where a person charged with terrorism-related crimes had died under mysterious circumstances upon being released on bond. So in the view of this, the court released the accused on bail for his protection. So the court denied the accused person to be released on bail because of his protection. So the court sometimes protects the accused person and prevents the release on bail, because when releasing the person on bail, his or her life will be in danger, as it was held in the case of Malindi versus Republic. Judicial notice offenses and the person charged with terrorism-related crimes. So releasing these persons will pose his or her life in danger. So the fact that the accused has been supplied with witness statement does not warrant the denial of bail, unless there is evidence of a real likelihood of the accused interfering with the witness. So there must be a clear evidence that accused will interfere with the witness. So in the case of Peter Mawia, High Court at Mombasa, criminal case number 48 of 2015. The case of Peter Mawia, High Court at Machakos, criminal case number 48 of 2015. So bail should not therefore be denied on weak grounds, but on real cogent grounds that meet the high standards set out in the Constitution. So bail should not be denied on weak grounds. The prosecuting side must demonstrate strong cogent grounds that will qualify the denial of bail. It should not be based on weak grounds as set out in Article 49 of the Constitution. All allegations of witness interference must be supported by evidence. You must give clear evidence that will show the proof the God that this person when released will affect the witness, that this person when released will be a threat to the public security. There must be a cogent evidence. So the court in case of R versus Joktan Mayende and 3 others, High Court at Bungoma, criminal case number 55 of 2009, indicated that intimidation of any kind aimed at influencing the compromising the witness amount to the interference with the witness. So the court held that intimidation of any kind aimed at influencing or compromising a witness amounts to interference with the witness. So if compelling evidence arises after the accused has been released or granted bail, the court may properly review its earlier order and detain the accused person. So if this evidence is released later on, after the accused person has already been given bail, then the court can review the earlier decision that granted this person bail and then proceed to detain this person if this person was a threat to the public security, or he was threatening the witness, or any evidence of cogent evidence is provided there later on. So let's look at bail in minor offenses, and we have those minor offenses that are stipulated, like those ones in the Traffic Act that are less than 6 months. So under those cases, bail should be granted, and this person who wants to receive that bail must demonstrate good behavior, should appear in all proceedings. It should appear in all proceedings, and he must demonstrate good behavior. So the court may not detain an accused person who is charged with an offense that is punishable by fine only, or imprisonment for not more than 6 months, according to Article 49 of the Constitution of Kenya. So that, together with the offense envisaged by Article 49 sub Article 2, can have a reasonable condition attached to the release on bail. So some of the reasonable conditions include requiring the accused person must maintain good behavior, attend to court when required, provide security in the form of bond or security, and refrain from interfering with the witness. So the court may also impose restriction on traveling out of jurisdiction. The court must also ensure that bail conditions are reasonable and not excessive, as this would lead to de facto imprisonment and amount to a violation of Article 49(2) of what is reasonable and should be determined in the light of the facts of the circumstances. In the case of Republic versus Chalco Kitende, Mainga High Court at Nairobi, criminal case number 65 of 2010, offenders charged with minor traffic offenses might not be denied bail, but dealt with according to Article 49(2) of the Constitution of Kenya. So minor traffic offenses must be tracted. So according to the guidelines, guidelines on handling of traffic matters, so there are those minor offenses that should be given, bail should be given or granted, and to those offenses. And this person must demonstrate good character, should attend all courts, and should provide security or guarantor in those cases. So let us look at bail consideration for a child. So a child is also supposed to be granted bail. So consideration in bailing or child cases involving children must be guided by the best interest of the child and Article 53 of the Constitution of Kenya. So Section 412 of the subsection 2 of the Child's Act or Children's Act, and paragraph 4.4J of bail and bond guidelines. So in the case of JMK and 9 others versus Republic High Court at Garissa, Criminal Appeal number 24 of 2014, children should only be denied bail or as a resort when it is when it is deceased, the child should be expelled. So the children offenses must be involved. The children officers must be involved. So the children officers of the officer of the children must be involved in that bail, because the children are not eligible for making their own decisions because they are not mature enough. So the officers should be involved. And if in case there is a denial of bail, then they should be provided. A remand should be provided. A remand room should be provided, and this remand room should be safe for that child and should consider the gender and the sex of that child. So a child should be stored in a remand room, and the period for the remand room should not exceed 6 months if the offense is punishable by death, and it should not exceed 3 months for any other offenses in the children's offenses rule. So let us look at the securities and the sureties. So the security are the guarantors, or they are acceptable person by the accused person. So when this accused person is serving the bond period, they're supposed to select a security person, and this security person will act as his representative during that period. So this security person will give any property that is holding as a security to the court, either a title deed or a logbook to the court to be held as a security, and the court should ensure that this document the one thing that is being held is valid and should not be transferred. So the court should inquire about the security person, and to ensure the attendance of an accused who is released on bail, the court may require the accused to provide or more security. So the accused person can provide not only one security but more security according to section 131 of the CPC. So the court must determine the suitability of this security. So the suitability of this security or this person who is chosen, acceptable person or the guarantor, is determined by the court through examination on oath. The court conducts an examination of oath to determine the suitability of this guarantor, and the court includes so this is considered by the court include paragraph 4.40 of the bail and bond policy guidelines. So the court forced those policies under the bail and the bond policy guidelines. So in the case of R versus James Kiarie Mtengei, High Court at Kajiado, Criminal Revision number 1 of 2017. So these are the consideration. So the security person should be financially liable to meet the obligation in the terms of the bail, should have that financial liability, should be capable of meeting those terms in the bail of the accused. So the character of the security person, the court should also note the character of the security person, the nature of the accused relationship with the security person. So it's upon the court to determine the relationship according to the guidelines in the bond, and to determine the relationship between the accused person and the security who is being given by the accused person. So the safety of the residence, security's residence. So the court should also determine where this person or the security resides, and other factors may have bearing the security compliance with the bail term. Any other factor that may have security compliance with the bail term. So the court must be certified that the proposed safety security understand the obligation and of a security and is willing to assume the role. So the court must ensure that this security has given consent and he understands the obligation that he is supposed to serve as a security, or as he provides the security. So the examination of the securities of a security is a judicial process and must be put on record And in the case of R versus James Kiana Mtenge, the court here that a trial court must examine the security and examination must appear on record. Every examination of the security must be recorded. So the court noted that the record from the trial court provided no indication that examination had taken place. So the court also held that the prosecution ought to have been involved in the verification and information provided by the accused and the security. So the prosecution side must also be involved in the verification and in the information provided by the security. The prosecution side must also be involved in that process. So upon approval of the security, if the person's residence is established, if this person is competent, he understands that is verified, he understands all those terms that are there or restored as a security, if the financial stability is okay, if is not the relationship between him and the accused is established, then the safety and the residence is established, then the court should explain clearly. The court should explain clearly, and the accused abscond and breach the trial terms, the security will pay the penalty and forfeit the bail and bond. The penalty will be paid by the security. So a security may apply to the court to be discharged. So a security can die during the bail process or during the term of the bail. So if a security dies, then the accused person can provide another security to replace the one who has died. So a security can apply to the court to be discharged according to section 128(1) of the CPC. When this application is made, in the observance of the accused, the court should order the accused to provide other sufficient securities. If the accused fails to do so, he or she will be remanded into custody according to section 128(3) of the CPC. So similarly, when the security dies before the bond, the court should discharge the person, and the estate and the money may require the accused to provide another security. So the court should discharge every estate that is being held of this security, and that person should provide another security. The accused person should provide another security according to section 129 of the CPC. So where the accused person is required to provide a security so as to be released on bond, the court must be furnished with the security documents such as the title deed, motor vehicle logbook, and the insurance bond. And in addition to that, the security documents of the court may require valuation reports relating to the value of the property being offered as a security, especially where the security is for a substantial amount. So the court may also require a valuation report in relation to this property that is being offered as a security, relating to the substantial amount in that bond. So upon acceptance of the title deed of motor vehicle and logbook as a security document, the court should make an order to restrain the transfer of any interest in the said property, the secured property. So the order should be served upon the land registration or the registration of motor vehicle. So the court can send an order to prevent the transfer of interest in that piece of land or property. So if this person security has given the land or the title deed, then the court will send an order to the land registry to prevent the transfer of interest in that land to another person. So the accused absconding the security must be ordered to affect the court and pay the penalty as shown in the court. The penalty should not be paid. So that is about the securities. So if the accused absconding, the security must be ordered and attendance to the court to pay a penalty shown. So guys, I think let's just review what we have learned. So we have learned about bail and bond. And the bail is that temporary release of an accused person upon he listening to a trial, when the trial is commencement of the trial. So an accused person pays a particular amount that will make him to be released. So we have looked at the compelling reasons that may deny bail, or where a person can be denied bail, and if this person is a threat to the public security, if this person being released will affect the witness or tamper with the witness evidence, and if this person being released will affect the victim's safety, and if his or her life will be endangered when he or she is to be released, then this person will be denied bail. So we have also looked at bail in children under bail, and we've seen that children to be offered bail, then their representatives must be aware, and in that decision must be involved in making a decision, because children have know that they do not have that capacity to make their decisions on their own, and if they are to be denied bail, then they should be held in safe remand, and depending on the age and the gender and the sex of those children. We've also looked at the bail. We've also looked at the securities and the security. These are the representatives of the accused persons. So the securities are the representatives of the accused person, and this security must offer their logbook, title deed to be held as a security, and the eligibility must be questioned and must be recorded by the court to show that these people are qualified or eligible as security. They must give the title deed, they must give the logbook, and a note, the registration, land registration. The land registration must be sent to prevent the transfer of interest to that piece of property that has been given or be held in security. And if this security dies, then the accused person is supposed to change the security as per the provision of Article 129 of the CPC, where it requires the change of a security to another person to be there as the security. And we also looked at the minor offenses, the bail in minor offenses, and the minor offenses as per the provision of they should be given, bail should be given in minor offenses, should not be denied in minor offenses. And these people who are requesting for bail in minor offenses, like those offenses defined by the Traffic Act, should demonstrate a good behavior. They should be appearing in all proceedings. They should provide a security, and they should not demonstrate any act, or they should not demonstrate any behavior of interference with the witness when they are released. So guys, that is the end of my episode and on bail and bond. And subscribe to Scores Legal channel, like the episodes, comment on the comment section how you feel about the lectures, and share the videos as well. So have a nice day.